Good afternoon, Tansei Anin. Welcome to APTN InFocus. I'm Daryl Stranger. There are many class action lawsuits ongoing in Canada, and many of them involving or impacting Indigenous people. Now, these lawsuits can take years before a decision or a settlement is reached, so we thought we would take a look at a few of them that affect Indigenous people. Today, we're putting class action lawsuits in focus. Now, as always, we want you to join in on our conversation. You can tweet us at APTN InFocus, or you can send us an email at infocus@aptn.ca. Now, let's dive right into this very important topic. So much for joining us here today on APTN InFocus. Now, your firm is representing a number of class action lawsuits, from forced sterilization to excessive force by the RCMP. Are you able to give us maybe a brief update on where these class actions are at?
I'll do my best. I mean, the nature of class actions is there's always discussions and developments that aren't yet public for a variety of reasons. You have to be able to have full and frank discussion. I don't want to sound like a politician, but full and frank discussion. Not always in the public eye. And given the nature of these claims involving so many people and so often nationwide, it's important to recognize that. But generally speaking, the class actions in which we're involved fall into two categories. There are those that are certified, and there are those that are seeking certification. So really, what does that mean? It boils down to a question of whether a court has permitted claims that would normally be pursued individually to go ahead as a group or a class, and that's the whole concept.
Right.
So the law doesn't change just because you're pursuing a class action. So where are they right now? I'll give you sort of the headliners. The first one that most people are interested in, it's the oldest and probably the best developed of all the class actions that I'm involved with, particularly those that have a class that is exclusively Indigenous class members, and that's Indian Hospitals case. That's been going on for quite some time now. It covers a period of time between 1945 and 1981 in which Indigenous population members were compelled by circumstance, by law or otherwise, to attend a series of, depending who you speak to, 30 to 32 hospitals across the country. That was certified on consent some years ago. Discussions have been ongoing for all of those years since certification, and certainly COVID slowed down what had to be, for a variety of reasons, in-person discussions. We simply didn't make a lot of progress in terms of discussions, but we did make progress in terms of research. We have a variety of cases involving the RCMP, three in particular in which myself and my firm are involved. There's what is referred to as RCMP North, which involves a claim against Northern Aboriginal citizens who had interactions with the RCMP that were couched by, that were informed by racism and discrimination, which we say was not down to an individual officer or group of officers or time or place, but rather represents the systemic racism and discrimination which has been present in the RCMP, we say, from its formation, and certainly despite many public pronouncements, continues to be an ongoing problem, an unresolved problem, and to a large extent unrecognized problem. So that one has also been certified, but it was not certified on consent. That was a contested certification, and it resulted in an appearance before the Federal Court of Appeal. Very recently, within the last few weeks, Federal Court of Appeal came down primarily on the side of certification, pruned, as the court said, some of the areas that we wanted to put before the court, but by and large, that certified class action is moving ahead as such. The government tried to decertify the class action, prevent it from going ahead, was saying that we're doing everything we need to, and this should go ahead where necessary on the basis of individual claims. That was denied at the Court of Appeal. There's a companion case in which I'm also involved in southern Canada, which really covers the rest of the country outside of the territories. The territories was unique in the sense that it really has one policing service, other than bylaw services and other sort of regulatory bodies. But the South is identical in every other respect. And the only difference is that, yes, there are provincial and municipal enforcement agencies, but we're not dealing with them at this point. We're only dealing with the RCMP. Right. So in that case, we are not certified, but we're getting very close to certification because they are largely running in parallel, although the Southern case was started later, so it's a little bit behind in the hopper. So those are the certified cases with which we are dealing. Those all involve discrimination. There is yet another one that is pending certification and is as close to certification, the certification hearing anyways, as any of the other cases, and that involves RCMP members. So these are not people that were interacting with the RCMP outside of the force, but rather inside of the force.
Okay.
And so discrimination, systemic discrimination and racism is not unique to people just out of uniform. The people in uniform were also subject to, we say, to the same sort of discrimination. And that one is approaching certification. There are others. I can go on if you want a complete list, but let me stop the monologue and turn it back to you for a moment, Daryl.
Well, given all of those cases that you had just mentioned, I feel I have to ask, why is it so important for you and your firm to be doing this kind of work?
When you think about the historical nature of these claims, it's just about time. I mean, these claims as individual claims rarely, if ever, go anywhere. There's a variety of reasons for that. There are strength in numbers, let's face it. The threshold for commencing a class action is such that not only does the group of people that you purport to represent as part of the class, not only do they need to have commonality amongst themselves, but it has to be both a productive use of court time, and there has to be an overall reason for going ahead as a group. And so class actions that my firm and others like ours pursue really do reflect societal wrongs, historical and ongoing wrongs that need to be addressed. And so we force institutions, churches, governments, cities, and provinces, for example, we force them to confront the problem. And we do it in a way that we are not, as a group, as a class, we are not beholden to the government. So, for example, in the Dirty Water case, it was decades of unresolved problems that took a class action to compel the government to do something about it. And it's the same thing with the RCMP. Residential schools was a bit different in the sense that that was a historical wrong that needed to be acknowledged. It was part of reconciliation, and compensation needed to be paid.
Right.
But without class actions, things don't happen. And we know that because we're representing people from back in the 30s in some cases, where nothing has happened and nothing would happen. And but for firms like ours and lawyers, I might say, like me, that hear about these cases and are approached, if we didn't take them on, nothing would change. So it's like the civil rights movement in the 60s. We simply provide the opportunity to get these cases dealt with, not voluntarily, not politically, but under mandate of the court. And that is what makes our justice system so strong in this country. It allows disenfranchised or discriminated groups to come forward en masse.
Well, and Stephen, how difficult, or has it been difficult to find these class claimants and to find people for these classes?
Well, if by class claimants you mean the representative plaintiffs, it's not difficult at all in most cases.
Okay.
These cases are notorious. These cases involve a lot of people, and firms like ours are magnets for people like that, understandably, because they see us in the news, they see us on programs like this, they see the success that we've had in the past in getting matters resolved. And they tend to find us. So the representative plaintiffs who represent the classes that we want to bring before the courts and hold the government and institutions accountable, they tend to find us. And we take their ideas, and there are many potential class actions, but we take the ones that seem to have the most merit, not just economically and legally, but also socially. And, for example, when we're going ahead with Indian hospitals, these are hospitals that existed for decades. The class period is 1945 to 1981, just against the federal government. So almost 40 years in that instance. And we find that there are lots of people out there that are survivors, and their stories are finally told through the class action process. As far as if you're speaking about class claimants as members of the class, they find out about us once a matter is certified, and thereafter once it is settled or adjudicated in favor of the class. They find out about it by an institutionally funded mass media campaign. And it really does keep up with technology. So I saw when we settled the Labrador residential school action back in, 2017, that class action resulted in targeted Facebook posts, for example. So people don't always find out about it in a timely fashion, but most people do in most cases.
Well, you touched on my next question, and that was just me going to be asking you, how do you advertise for these, for them? How do you advertise for them? And you mentioned, so it's a bit of social media, I guess, a little bit?
Yeah, so again, we don't advertise for representative plaintiffs, but by class members,
Right.
which could be characterized as class claimants once the matter has been settled or adjudicated in favor of the class. It really is just mass media. So we use social media. People like me come on programs like yours and talk about it. It's really hard to escape the information, even if you aren't looking for it. If you're looking for it, then it's easy to find. The other way, frankly, is we encourage people to contact us. So, for example, I don't know the exact number, but it's about 4,000 or 5,000 people in the hospital's case are in our database. They don't need to look for the information. We push it out to them, and as settlements or major milestones are met, they get information. So it's extremely important for a number of reasons that potential class members, they don't need to know whether they're class members, they just need to think they might be. Contact lawyers like me, get yourself in the database, because we also use that data anonymously to give to experts to help us formulate what a settlement might look like. If we don't know that something has happened to a number of people, that tends not to be included in the settlement. And so the importance of contacting the class action lawyers involved is both selfish in the sense that you get put onto an information stream. You're part of the information highway then. But second of all, in an aggregated form, aggregated, not aggravated, form, we get to use the information anonymously for statistical purposes, and that's what settlements are based on. They're based on stats.
So while we're on the subject then, the purpose of our show today is to update our audience with how they can participate if they believe a class action applies to them. So what is your advice then in this case?
Call me. If it's a case in which we're involved, or if it's a case you think has some merit, just call me. I mean, you can call our toll-free number. I sound like an advertisement now. You asked me about advertising. Here it is, I suppose. 1-800-994-7477. You can contact info at Cooper Regal. Regal's with two E's, not an A. COOPERREGEL.ca. And just ask us questions or give us information. We have questionnaires available on each of the claims in which we're involved. Where settlements are negotiated or adjudicated, then we have claim forms that are also available in the same place.
Okay, perfect. We'll get that info out there. And when it comes to working on a class action, or maybe launching a class action lawsuit, what are the resources like, and what are the resources like for involving them? How many lawyers are working on them? Can you give us a bit of maybe insight into what goes into that?
Yeah, sure. I mean, I've always said to junior lawyers to remember that law firms are kind of like black boxes. You know, people come in, something happens, rattles inside, and something comes out. And so it's important to sort of look in the box or lift the curtain. There really isn't any magic about it in the sense that we assign a number of lawyers and other staff that are necessary, and that ebbs and flows depending on what type of case it is and where you are in the case.
Okay.
So as we're collecting information to convince a court to allow a class action to proceed, because unlike other actions, you need the court's permission to even get started. So you have what's called a putative or proposed class with a putative and proposed group of issues and people. So we assign a number of people, lawyers, paralegals, and experts as is necessary. Historical claims always involve archival searches and experts. Every one of our class actions that go back more than 10 years, for example, require archival research. A distinction, for example, in the privacy breach in the Northwest Territories, which we think affected 60,000 people, but not uniquely Indigenous in that case. Right. We're not looking at historians, we're looking at technical experts, trying to help us understand how such information is misused on the dark web or otherwise.
Right. And Stephen, in the case of historic abuse, like the Indian hospitals, how cooperative has the government been in providing documents?
Well, the court compelled to. I mean, the rules of court compel a party, and it doesn't matter if it's a federal court or the guy next door or the girl next door. They're compelled to give us whatever they reasonably can access. So it's give and take. I mean, we will, and our experts in particular will say, we need information on this. What do you got?
Right.
Okay. The problem really is less with the defendant, in this case, the federal court, and it's more with third parties, because the reality of Indian hospitals, as we've discovered, is that the archives that do exist are deficient because of normal destruction policies and loss and fires and just misfiling and mishandling. But also the documents are everywhere. I mean, I was shocked to find out that the city of Edmonton archives apparently have a huge amount of information about one of the largest, if not the largest, of the Indian hospitals, as they were called, which is the Kamsel Hospital in Edmonton. And for some reason, some of the archival material was transferred to the city. That came as a surprise to us, so we have to approach them. The Northwest Territories, the Prince of Wales Heritage Museum, for example, which is the official archive of the GNWT, has some. So finding documents is not just about the cooperation of the defendant, in this case the federal government, but of figuring out where things are and often seeking court orders along the way to ensure that the material is available. What happens with third parties is that they'll often, and quite reasonably and justifiably, say, we can't give you this information. We'd love to, we'll cooperate, but you need a court order. So then we have to go to court, often with the cooperation and collaboration of the defendant, to get that information. And sometimes the most important information is held personally in people's files. You know, photos of people, Anne Hardy, who's our representative plaintiff in the hospital's case, for example, has a very compelling picture of her while she was a patient at the Kamsel Hospital. It puts her there, one of the things. And then they tell us things as well. So we discovered through some of our putative class members, in that case class members, about a radio broadcast that was done from Kamsel and internal news sources. So the documents are found everywhere on these types of cases, and that's unfortunate. It makes it really difficult to get a complete understanding of what happened, and it makes it difficult to prove that somebody was there if that's necessary.
Well, Stephen, there's certainly plenty to think about and a lot of information there, but we certainly appreciate you coming on and sort of breaking that down for us. And I know our audience is going to be that much more knowledgeable should they maybe think they're part of a class action. So again, thank you so much for coming on, and this is such an important discussion. So we really appreciate your time.
Information is power, Daryl. Thank you so much for your interest.
Well, let's go to social media now with our social media editor, Jesse Andrushko, to hear what some of you are saying about today's topic.
Thanks, Daryl. Online, we asked, do you feel class action settlements are the way to right historic wrongs against Indigenous peoples? We received a lot of comments. First, let's take a look at those who are more opposed to fighting in court. On Instagram, Callie said, no, you are ruining our future chance at proper compensation for short-term gain. From Talon, money doesn't heal the genocide that is still ongoing. Money doesn't buy lost languages or sovereignty. Matt said, no, health and psychosocial well-being comes from land, language, and culture back. Lastly, Lloyd said, no, but that's all Canada has to offer is money. They never talk about giving the land back. Now let's take a look at those in support of class actions. First from Joey. Yes, but I think reparations we should be getting are land reparations, like New Zealand. Joel said, yes, I feel we owe First Nations for what has been taken from all elders. Nathan commented, yes, Canada is full of ingrates. Take it to the courts. The treaties were clear. Time to learn. Lastly, from Lily, yes, there has to be some sorts of compensation for people wronged this way. Thank you to everyone that took the time to share. If you want to add your opinion, here's how. Join our conversation now. Like us on Facebook on our APTN News page. Follow or tweet us at APTN InFocus. And send your thoughts to infocus@aptn.ca.
All right, thanks for that, Jesse, and thank you at home as well for contributing. All right, we have to step aside a moment. We'll have more on class action lawsuits when we come back. Welcome back to APTN in Focus. Let's keep these interviews rolling, and our next guest joining me here on the show is our own web-based reporter, Danielle Parody. Danielle, thanks so much for being with us here today. Now, you've covered the story of forced sterilizations among Indigenous women. So, first off, what can you tell us about this issue?
Thank you, Daryl. This is an issue that goes back a really long way. I think that's the first and most important part to understand. I did a deep dive in the archives. For example, in Alberta and BC, there was actually a law called the Sterilization Act, which did not apply solely to Indigenous people, but a lot of Indigenous people were sterilized as a result of the acts. In fact, more and more as time went on, which was interesting. One example is Rosie Paquette. She's from 1932. She was in a training school, which was a sort of institution or prison for people who were who had cognitive impairment or were developmentally delayed. So Rosie and her father both consented, and I put a little bit of an emphasis on consent because, of course, we know that Rosie was developmentally delayed, and being sterilized meant that she was able to go home with her family. So now we look at that and we think, is that consent in the way that we understood? Move forward to today, past the 70s, past the Sterilization Act, and you're still hearing women as late as 2018, maybe even later now, talking about how they underwent this surgery, not fully understanding that it was a permanent solution.
Right, and Danielle, like you mentioned, this has sort of been going on for almost 100 years, really, like with that one story that you just shared. And one of the stories that you also broke was about the infighting between the lawyers on this. I think this is just fascinating. You don't hear about this every day. So what can you tell us about that infighting?
Yeah, so the story I wrote was about both Alyssa Lombard and Worm Semiganis Law, and there was some lawsuits between the two having to do with funds and whether or not they were appropriately handled, and then a countersuit. So I stumbled into that story through hearing from a source that she was having some frustrations about getting a hold of lawyers and having her questions answered. So when we've heard a little bit from the last guest about the administration and the length of time that it takes to get to a certification. We also have perhaps a lot of administrative confusion. You have people switching law firms, and you have multiple law firms that are involved and looking for complainants to sign on to the class action. So yeah, it was a really interesting peek into how law firms work behind the scenes.
Well, so then my next question is can you clarify for us how many lawsuits there are, or is there just the one, and where these are?
Yeah, that is a really good question, Daryl. So I'm just going to say this is what I could find, because there are always lawsuits that seem to come up and maybe still be looking for complainants. In Quebec, there are at least 12 women signed on to a lawsuit. It's supposed to go for certification this next month in May 2023. There is one in Saskatchewan, and that's Alyssa Lombard, who's also dealing with one in Manitoba. There's a lawsuit in Alberta. I believe that's Koski-Minsky, and then there is British Columbia as well. There's been a notice of civil claims filed in BC. So I think there are a number of law firms that are looking to advance this and see some accountability for hospitals or jurisdictions that have done the sterilizations without the necessary consent. And of course, in our country, the health is primarily on a province by province basis, the exception being First Nations, where there's the agreement with the federal government and the funding runs through the federal government, sometimes into bands and then sometimes into the province. So confederation is an interesting thing.
Yeah, it's a great point you just made there, Danielle. And you've also spoken to one of the women involved in the lawsuit, right? So what is she saying about this?
Yeah, so I spoke with her name is Luana Robertson, and she was in my article where she was trying to look for some answers. Now, Luana was primarily coming forward. You don't see a lot of people wanting to speak out about this because, of course, it's a very personal matter. It's a real vulnerable thing to talk about being sterilized. So Alyssa was concerned that maybe other women were having trouble navigating the system as well. And so she wanted to speak out about that and her troubles finding what was going on. And as we heard from our previous guest, there's a lot of steps that happen in the certification process, and it often doesn't move as quickly as we hope. I did speak with Alyssa Lombard just today, actually, to ask if there were any updates. She's hoping to move forward for certification in the lawsuit in Saskatchewan by June. And at least in Saskatchewan, although it might differ from jurisdiction to jurisdiction, it's opt-out. So they get control of medical records and evaluate who fits into that criteria. And so you don't necessarily have to call. However, as your last guest has put his name out there and is interested in having people call, I think if people are concerned, they should, Google around, check out what lawsuits are in your area, and send an email, because it is quite stressful for women that have shared their story, like Luana.
Yeah, well, you touched on a very important point there, and you said it could range from jurisdiction to jurisdiction, right? And you just mentioned the one in Saskatchewan is opt-out, right? So the final question before we let you go is, so who's eligible, and what do they need to do to be included in this? And I guess it would vary in each jurisdiction?
Yeah, I think I'm not super familiar with the requirements per jurisdiction, but even though we're dealing with maybe multiple law firms and multiple jurisdictions, some, like the guests we just heard from, have law offices in different places. So yeah, it's not a very easy answer. I wish I had a very straightforward answer for the listeners, but I think the best thing that you can do is consider where your province is, and class action, do a little bit of search engine looking up with where you are, class action, and the law firms will pop up. They do have pretty good search engine optimization and show up. That's where I'm finding that information as well. But it is just not as straightforward as one national lawsuit that you can sign on to.
Yeah, it never seems like it is super simple. So Danielle, we really appreciate you coming on, and I know, especially with this, it seems like it's just really confusing, and people might seem like, oh, I don't really know where to go, but that's some really good advice, and just maybe do a bit of your own research, and if you have questions, reach out to a lawyer in their own jurisdiction. So Danielle, we really appreciate your time coming on here and for clearing up a bit of what's going on with forced sterilizations anyway. So thank you so much for coming on.
Thank you, Daryl.
All right, our next guest joining us is a lawyer, Corey Wanless, who has worked on the Day Scholar class action lawsuit. Now, in this case, students who attended a residential school during the day but did not stay overnight are eligible to make a claim. Now, I spoke with Corey earlier for more information on the case. Corey, thank you so much for joining us today here on APTN InFocus. First off, can you just tell us about the Day Scholars class action lawsuit and sort of what that entails?
Sure. The Day Scholars class action is one of a number of lawsuits regarding residential schools. This is particularly regarding day scholars, who are individuals who attended residential schools during the day only but did not sleep there at night. And day scholars were left out of a key part of the Indian Residential School Settlement Agreement. In particular, they didn't receive the common experience payment. So this class action, this lawsuit, was an attempt to fix that injustice and to include the excluded. And there was a settlement in this lawsuit a couple of years ago now, and now we're in the claims process to make sure that everyone who's entitled to compensation receives compensation.
So speaking right on that, so then who can apply for this compensation, and is there any help for those who are looking to take the first steps and they think they might be eligible?
Yeah, so the individuals who are able to apply for the Day Scholars compensation payment are survivors, those who attended residential schools during the day only. There's a website that provides a lot of information and also can provide a link to make the actual claim. It's justiceforDayScholars.com. Okay. And that's the best way to get started. So Justice for Day Scholars, searching using any search engine. And on that website, you will find a list of residential schools and also the dates that those institutions operated as residential schools. And so folks should go to that website and see if there's the institution that they attended is there, and to make sure that they attended on those dates. And after that, the application process is actually quite simple. It's best if it's done online. And all that's required is confirmation that they attended as a day scholar at an institution that had day scholars during the dates in which it operated as a residential school. And that's it. There's no need to get into further information regarding anything that happened while in attendance. It's just all that's needed is confirmation that they in fact attended.
So then what does that confirmation look like, Corey? Well, what sort of documentation would that be?
Not very much. Basically, it's just an application form. In certain instances, it requires folks to to state some information about where they were staying at night if they were not staying at the residential school. But no documents or proof or anything like that is required. It's just a simple application form. We tried to keep it as simple as possible to make sure that everybody's entitled to compensation gets it.
Okay. And is there a deadline for this?
There is a deadline. It is October the 4th of 2023. So folks have some time, but that deadline is coming up later this year.
Mm-hmm. And just before we let you go, I just wanted to ask you, how does this one differ from other class action lawsuits? Is there maybe a unique difference about this specific case?
Yeah, so it's unfortunate that there's a bunch of different class actions that have been resolved recently and settlements that have made things pretty confusing for people. A major area of confusion is between day schools and day scholars at residential schools.
Right.
And this lawsuit that I'm talking about is not for day schools. That was a separate settlement process that is now wrapped up. It's no longer possible to claim under that lawsuit. This one is for students who attended residential schools during the day only, the day scholars. So that's an area of some confusion.
Well, Corey, I just wanted to make sure we cleared that up, and I'm sure our audience appreciates you coming on, giving us an update and how to apply for this. So we really appreciate it. Thank you so much for joining us here.
Thanks very much for having me. I appreciate it.
Well, in January of 2023, survivors of the Île Crosse, a residential school in Saskatchewan, launched a class action suit against the provincial and the federal government. The survivors group and supporters turned out in force as the court filing was announced for a proposed class action lawsuit. They're seeking compensation for the harms done at the school, where approximately 1,500 children, mainly Métis, attended. The Métis Nation of Saskatchewan says the survivors have been denied benefits from other settlements for too long.
The Île Crosse Residential School is one of the oldest schools in Canada. So when you think about that and you put it into context, over 100 years and 6 to 7 generations of harm in that school. And it didn't just affect Île Crosse. It affected all of the surrounding communities in northwest Saskatchewan. You see the suicide.
Now, the survivors group hopes the action spurs both levels of government to come to the table to work out a compensation package. Failing that, it says the case will go to court. Now, the MNS says its support includes a financial backing for a lawsuit, but they didn't give a dollar figure. All right, we have to put a pause on our show one final time. We have one more interview when we come back. Stay with us.
Our APTN News page. Follow or tweet us at APTN InFocus, and send your thoughts to infocus@aptn.ca.
Welcome back to APTN in Focus. Our final guest joining us this afternoon is Angela Besflug. Angela is a class counsel on a number of class actions, and I spoke with her earlier to tell us all about those. Angela, thank you so much for being here on APTN in Focus. Now, you are a class counsel for a number of class actions ranging from sexual misconduct to Indigenous rights and others as well. Can you tell us a bit of what you're currently working on in regards to those?
Yeah, so my practice largely focuses on policy-based class actions. So class actions largely against various crowns that focus on human rights to some extent. So as you note, a lot of Indigenous rights cases, sexual misconduct cases, veterans cases. Right now, one of the biggest cases and or series of cases I'm working on have to do with the Indigenous child welfare system. And as we all know, that system is very broken, and there's a hugely disproportionate representation of Indigenous children in care throughout Canada. So about 3 years ago, I filed a class action on behalf of 3 Indigenous individuals, 2 of whom are First Nation, 1 of whom is Métis, that sought to hold Canada accountable for the harms caused to them and others like them as a consequence of being apprehended from their families, from their Indigenous communities, and placed in the care of others who are not members of their Indigenous community group or people. That's kind of a novel action because in the past, Canada's kind of washed its hands of First Nations and other Indigenous children who reside off reserve land. So this case said, no, not okay historically. You've always had an obligation to, obligations with respect to, Indians and land reserved for Indians, First Nation individuals, Aboriginal rights by virtue of Canada's constitutional obligations. And so we said, you can't just wash your hands of that. Mm-hmm. And so, beginning in the late 80s, early 90s, Canada stopped paying for off-reserve Indigenous child welfare. So prior to that, it actually had recognized its duties. It paid for the care of those children, and then it just stopped doing so. So with that action, we said, no, enough is enough. You play a vital role. You, Canada, play a vital role in this current crisis. We need you to step up and start taking responsibility for curing these harms. Mm-hmm. So that action was certified by the federal court back in June, and so we continue to push forward on a national level. From that perspective, the goal obviously is twofold. One, not only to compensate these children for their loss of cultural identity, which is huge, we know has, intergenerational impacts and effects, but also to seek much needed reform of this broken system. As a kind of follow-up to that, we filed a series of provincial actions with our co-counsel across the country, so British Columbia, Alberta, Saskatchewan, Ontario, and Quebec. Again, with a focus on the provincial element and the lack of underfunding for Indigenous child welfare, and specifically the lack of funding for preventative care.
Right. And Angela, just staying on the CFS one for a moment here, there's so many privacy considerations when it comes to CFS as well. Has it been challenging at all for you and the firm to find plaintiffs?
So I would say no, because it is such a crisis, and I think that we get so many calls weekly and monthly from individuals who have been impacted by the child welfare system. Not always, the children who are maybe now young adults, but often from their parents, either parents who are still lack that relationship and connection with their children because they were apprehended from them when they were so young, or because they're looking for a recompense for past harms because they did lose so much of that time with their child and that family connection. The interesting thing is, we say these are obviously very, very complicated issues, but they're all grounded in intergenerational trauma, Canada's past policies of assimilation, residential schools, day schools, boarding homes program, all of these programs, as we know, were designed to really to take Indigenous children and youth away from their families and communities, mm-hmm. and to assimilate them into mainstream Canadian culture. And the impact of that, we see so many clients who their grandparent was part of the 60s scoop, and then their parent their grandparent was part of residential schools, their parents were part of 60s scoop, they then were apprehended from their parents, and it becomes this cycle that I think is so hard to break free of. And very clearly there needs to be much more funding put into preventative care, because the solution and the impact of removing children as a matter of first resort, as a matter of last resort, has such devastating consequences. And we see that in the numbers. We see that in the drastic overrepresentation of Indigenous children in care. It's not working. It's not a system that works.
Well, and Angela, one more on the CFS, and then we'll I'll ask a few other questions. But I wanted to ask about why are there multiple class actions for the same issue? I'm thinking of the settlement this week for the $23 billion also for CFS. So why are there multiple on the CFS issue?
Yeah, so the one you've been hearing about deals with First Nation children who've been apprehended on reserve land. We say, so the Stone Child, the other action I was referring to initially, that action deals with First Nation and other children who were apprehended off reserve.
Okay.
We say there's no principled basis to distinguish First Nation children living off reserve from First Nation children living on reserve. They're no less Indigenous by virtue of having been forced essentially in the past off their reserve land because of Canada's assimilationist and colonial policies. So in effect, Canada's been able to benefit by, its policies which took Indigenous First Nation people off their land, moved them into mainstream society, and then Canada was able to wash its hands of them from a funding perspective and otherwise. Mm-hmm. So for Canada to deny responsibility for these off-reserve kids when they're finally acknowledging their role with respect to the on-reserve kids, we say is nonsensical, because the only way they can justify that is by a position that inevitably has a consequence of them saying that those children are less Indigenous, are not truly Indigenous by virtue of now residing off reserve land, which we know can't be right and isn't right. And there's so much of the First Nation population and Indigenous population generally that is scattered throughout urban centres across Canada. And what we need to do is try and reconnect those individuals with their culture and their communities, not to further create a divide.
Right. And I'll ask you sort of a broader question overall about class actions, and it seems like class actions are needed really in order to get things done or to help get people compensated for whatever the case may be about. Why is that the case where a lot of times something like a class action is needed for any action to be taken? Yeah,
I mean, it's sad in a way that, often, I'd say almost all of the class actions that I pursue and I'm involved in, there's so much evidence already on the record of wrongful conduct and the harm caused by that conduct. Now, it doesn't always mean you're able to prove that by a civil standard, but certainly most of these cases, it's well known. There's so many studies and reports and otherwise, and the Indigenous child welfare context is a perfect example. This problem of this epidemic of overrepresentation of Indigenous children in care is not unknown. It's known. It's been known for decades. Been known to be grounded in assimilationist policies. It's a crisis that has been spoken to and about by various ministers, and yet here we are. It doesn't get fixed. It's only, any acknowledgement of the issues is often just lip service. Whereas what we need is not only, we need far more than that. We need actions that show a willingness to fix the acknowledged wrongs or the acknowledged harms. And yes, those are very, very complex, remedies. These are not easy fixed. These are multi-year fixes that probably involve not only legislation, but a whole, shift in ideology. But those reforms never seem to happen without the financial pressure and the political pressure by virtue of media and whatnot that these class actions often bring. Without that, there seems to be no actual change. So, I certainly use the vehicle of class actions as a mechanism, not only to try and get compensation for past harms for individuals who are so deserving of that, but more importantly, to try and reform, very broken systems.
Yeah.
And, these goals are not easy. I think nothing's perfect, but we try to push forward to change cultures, to change policies, to change guidelines, and hopefully in the end to remedy, at least to some extent, these issues.
Well, that's really well said. And sort of on that same topic, are there any more upcoming class actions that you can tell us about at this point in time?
Yeah, so as noted on the Indigenous child welfare stuff, that's been busy and active for the last few years, seeking compensation for the children. We recently also filed an action on behalf of the First Nations themselves for the collective harms that they suffered as a consequence of the apprehension of their children. I've got an action that deals with alleged systemic negligence against the province of British Columbia with respect to racial discrimination in the healthcare system, and the effect of that is not only that often First Nation individuals are turned away or improperly triaged at hospitals, but also has the effect of these individuals not even wanting to seek treatment and care when they need it because they're worried about improper and stereotypical assumptions being placed on them. Right. So that's an action that's ongoing. I've got an action that deals with sterilization and forced abortion of Indigenous individuals. And that's a problem that's gone back decades and decades, that originally was sanctioned by legislation, but the kind of continued perpetual effects of that carried on throughout residential schools, 60 scoop, day schools and onwards, and even exist in the present day, which is exceedingly shocking. Although I guess we shouldn't maybe be shocked. These continued policies of assimilation and trying to curb the Indigenous population. These are still very real issues, as egregious and as horrific as they are. They still exist in these various forms. And so, again, slowly but surely. And then I've got a hearing next week for certification that deals with, it's an action against Canada on behalf of the RCMP's alleged wrongful conduct vis-a-vis Indigenous civilians. So the action alleges that that the RCMP engages in systemic racial discrimination against these individuals, and that takes a form often of not only excessive detention and arrest, but also physical and sexual assault while these individuals are detained or otherwise in RCMP custody. Again, it never ceases to amaze me that, we get contacted all the time by First Nation individuals, Métis, Inuit, who, their stories are shocking and tragic. In this case, it's just another example of that. It's just truly systemic, ingrained behavior in our society that tends to treat First Nation individuals as second-class citizens. And it's obviously a system that's still very, very broken and very much in need of reform. Just chugging away slowly but surely, trying to make changes.
Well, Angela, there's certainly a lot going on, it sounds like, and a lot for us and for other people to be aware of and to be looking ahead to. So we do appreciate you coming on and updating us a bit on the work that you do and some of the class actions that you're working on. So thank you so much. And there's certainly, like I said, a lot to be looking ahead to.
Absolutely. We'll keep fighting the good fight, and nothing's perfect. But, let's hope that some of these actions not only result in compensation for these past harms, but play some role in shifting things moving forward and fixing broken policies and broken systems.
All right, that's all we have for you this afternoon on APTN in Focus. Now, today's episode will be available as a podcast. You can listen and subscribe on aptnnews.ca/podcasts, or you can find us on your favorite player. And if you missed any of our past episodes and you do want to catch up, or you missed any of this episode, you can find them and more on aptnnews.ca/infocus. For all of us here, thank you so much for joining us. Miigwech Kinanaskamatin. Have a great rest of your day.